All right, welcome to my YouTube channel. If you are meeting me for the first time, this is Counsel for the Rich only. Yes, I know you must have noticed that I've changed my name. It's no longer Prof TV. Yes, it is Counsel for the Rich only. Yes, because that is what I am. I am the counsel to only for the rich. You cannot be poor and you come to me to come and be your lawyer. Okay, so today we'll be doing. Oh, sorry, the light is. Let me turn it like this. Now today would be completing the elements of contract. I know that most of you have watched the playlist and you are wondering why am I not posting more on those playlists. I've been working so much. My table has been so loaded. But at least I have a little chance today. Today is a Saturday, and let us just see how far we can cover in intention to create legal relations. Now, we have looked at offer, acceptance, consideration. We are now going to look at intention to create legal relations. After that, we might go into capacity. Then we'll now go into terms of a contract. We'll now look at vitiating elements and all that. So we still have a long way to go. But intention to create legal relations. What is intention to create legal? When you talk about intention to create legal relations, what are you insinuating? Now, when you are entering into a contract, are you saying or are you intending that these contracts would be legally binding? Now, when I mean legally binding, are you saying or are you intending that when you enter into this contract and you breach the contract, that this other person that has suffered damages as a result of your breach, can he now sue you? Now, there are some matters or there are some kinds of contracts that ordinarily do not require you to have legal relations. If you are entering into this contract, you are not entering them because you have the intention to be bound legally. In fact, Professor Williston has stated that intention to create legal relations is nonsensical. Now, he didn't use the word nonsensical though, but he was saying that it is irrelevant. Because how is somebody going to enter into a contract without being bound by the contract? Like, what is now the intention of you entering into a contract if you don't think there is going to be legal obligation or there is going to be legal bindingness? Now, while this is true, especially when it is related to commercial agreements, however, in domestic and social engagements, it is presumed that you are not expected to be bound. Like it is presumed that there is no intention to enter legal relations. Now, I've given you two aspects. Number one, commercial agreement presumes that you have the intention to enter legal relations. And one thing about presumption is that it is presumption. You don't need to prove it. Presumptions need not to be proved. So you cannot come to court. Of course, if you come to court, you have to prove that okay, you made an offer. Yes, you made an offer. They will now start looking at the offer. Start looking at whether the offer was unequivocal, was actually an offer, or was it an invitation to treat. You have to prove that. You have to also prove acceptance. You have to prove, especially when you did not really outrightly say that you have accepted. Maybe by your performance, you have to prove that you were not ignorant of the offer while accepting. You have to also prove that your acceptance did not come off as a cross offer or a counter offer so as to make it invalid. All those ones, you have to prove them. Consideration, you have to prove that you actually paid or you actually did something on your own part to make it binding on the other person to do his own part. You have to prove all these in court. You have to prove consideration. You have to prove if you even furnished sufficient consideration, because of course you know that consideration need not to be adequate but sufficient. All these things you have to prove. In fact, I think in capacity too, you still have to also prove that you are not a minor. Probably, maybe if it is an issue, maybe if they raise it as an issue that you are not even up to 18 years and you're entering into this kind of contract that you're not supposed to enter, it's better to maybe bring evidence to prove that okay, I am not a minor or something like that. However, in presumption, especially when it concerns this intention to create to enter legal relations, it is presumed. When we say it is presumed that in commercial agreement, the intention is already there. It means that once it is commercial agreement, the law sees that there is presence of intention to enter legal relations. You don't need to prove that one. If the issue is whether or not there is an intention to enter legal relations, the law is already presuming that it is there in commercial agreements. So you don't need to prove that you had intention or you did not have intention or anything. It is already a presumption. The only thing left for the other party that is challenging that presumption is to rebut it. There's something we call rebuttal. Presumptions are rebutted. Something you call exceptions to your general rules. Presumptions are rebutted. For example, let's even deviate a little. Everybody is presumed innocent until proven guilty or until proven otherwise by the court of law. You are innocent. Even if you are caught in the act, you are presumed innocent. The rebuttal is when you have been proven otherwise. That is when you can now rebut that presumption against one person. So when you now prove the person guilty, that person is no longer presumed innocent because you have rebutted it in that person. Now, that is also how it is here. In commercial agreement, it is presumed that you have intention to enter legal relations until it is rebutted. We will still look at the rebuttals. Now, in domestic and social engagement, it is presumed that there is no intention to enter legal relations. So they are contrasting. The presumptions are in opposite. Commercial agreement. In commercial agreement, there is presumption that there is an intention to enter legal relations. While in domestic and social engagement, there is presumption that there is no intention to enter legal relations. Of course, there is still rebuttals. Well, exceptions in domestic and social engagement. So when you bring a matter to court and it is under domestic and social engagement, it is not a contract. You cannot say it is a valid contract because the law presumes that there is no intention to enter legal relations. And remember, we said that for a contract to be valid, the elements must be there. Anyone that is missing, it is no longer valid. Offer acceptance, consideration, intention to create legal relations, and capacity. So if the law is now presuming that in a particular kind of engagement or arrangement or agreement, that the intention to enter legal relations is not there, that means it is not a valid contract and you cannot enforce it. It being an invalid contract means that you cannot enforce it in a court of law. We will still get to that. Then we now have the intermediate situations where it is neither under the category of the commercial agreement nor the domestic and social engagement. Now let us just start explaining them. But I will have to start with the domestic and social engagement for some reason. Now, domestic and social engagement. Now let me ask you a question. If your father tells you that you, as you're in university, if you get a first class, I will buy you a car. Of course, the promise of your father and your own promise is what we can term as executory consideration. Now, if what I am saying is new to you, go to this playlist, watch all the videos in this playlist so that you will not be having the confusion. Now, the promise your father made and your own promise to make a first class is executory consideration. So consideration is furnished, but in an executory manner. You now do your own part of the bargain. You make a first class. Let us assume that you did not even make the promise. Your father just said, if you get a first class, I will get you a car. And you actually got a first class. That means you have furnished your own consideration. You have done your own part. You have accepted by conduct. Now remember we said that consideration moves from the promisee. Yeah? So you have furnished your consideration. Why is consideration moving from the promisee? So as to make the consideration binding on the promisor who made the promise. So if a promisor makes a promise and you as the promisee, you furnish your consideration, that consideration ordinarily would make the promise of that promisor binding. I know I'm not speaking Latin. Okay. So you have gotten the first class and your father, for some reason, say he's not going to buy the car for you. Can you sue your father? The answer is no. Why? Because it is a domestic and social engagement. Why is it that you cannot sue your father? Because it is not a valid contract. How is it not a valid contract? Because for a contract to be valid, there must be the presence of the 5 elements that we have just mentioned. And in domestic and social engagement, even though there is offer, acceptance, consideration, and probably even capacity, but the law has presumed that intention to enter legal relations is not present in domestic and social engagement. Very sweet and simple. So if your father promises you something, or your or husband and wife, the husband says, if you give birth to a bouncing baby boy, I will buy you GLE, Mercedes Benz GLE 63. And you, as the wife, you gave birth to a bouncing baby boy, and your husband refuses to buy you the GLE Mercedes Benz. Can you sue your husband? No, you cannot, because it is a domestic and social engagement. So read domestic and social engagement and get more knowledge on that. Domestic and social engagement, you cannot say that you have the intention to enter legal relations. You cannot say that you have the intention to be legally bound by something that you are doing with your wife. It's your wife now. Why would you want to come outside and come and do this? So we look at the rebuttal. When can you say that there is presence of intention to enter legal relations, even when it is domestic and social engagement? What is the situation that would make that presumption go away? What is the rebuttal of that presumption? Number one is when the husband and wife are not living in amity. When the husband and wife are not living in amity, when they are having katakata in their marriage, when there is no peace, when they, even most of the times, they are not even living together, when they don't they are on the verge of divorce, or they want to divorce, or they have divorced, or there is no love again in the marriage. So whatever contract that they're entering, they're not entering it with love. They're not entering it with my wife. No, it is seriousness. So if they agree to separate, and the ex-husband says, okay, I will, because you are with my children, I will be giving 20,000 naira every month, so that you'll be taking care of my child as child support, and we sign the agreement. If you don't now bring the 20,000 and you come to court, you cannot come and raise the presumption that in domestic and social engagement there is a presumption that intention to enter the legal relations is absent, and so this particular matter is not binding on me. You cannot make that argument, because the rebuttal of the presumption is when you are not living in amity, when you are not living together, when, not really when you are not living together, but when there is problem in the marriage. Let's just take it like that. When you people are no longer the husband and wife you used to be. So to a reasonable man, that contract is actually like it should be binding to a reasonable man, and that is the test that the courts would apply. The test of the reasonable man, the objective test, reasonable bystander. Will a reasonable man look at the contract and say that it is expected to be binding? Yes. But in a husband and wife, listen, you can just be using love and say, yeah, I will buy this one for you, I'll buy this one for you, I'll buy this one for you. Then if you don't buy it, then you now come and sue your husband because he promised you that he will buy you something when if you do well in the other room. So okay. So another exception or another rebuttal is when the performance of a social or domestic engagement has cost great sacrifice on one party. So it will not be unfair that you have told me that you, as my uncle, that you want to bring me over to United Kingdom. I should sell my house and get money to do the whole visa and everything. In fact, you are suffering from a terminal disease, that my name is on the will of the house you have in United Kingdom, and that I should come over so that I will, before you buy, I will get used to the whole environment and all that. And I sold my house, I stopped my education because of your promise, and I've even entered plane. I've come to UK. I stayed 1 day, 2 days, and we had some kind of fallout. And you said, in fact, I should get out of your house. I should go back to my house. In fact, that's the whole promise. I've ended it. So you cannot end it like that, though. I have made a lot of sacrifices, and that is where the second rebuttal comes in. When there is great sacrifice, when you now come to court, and you now come and tell my lord that, see, there is presumption that intention to enter legal relation is not present in domestic and social engagement. My lord will say it's a lie. Oh. That yes, in domestic and social engagement, because people are in one family and all that, there is a presumption that there is no intention to enter legal relations. However, when one party has suffered so much great sacrifice, or has made so much sacrifice due to your promise, then you cannot plead that presumption. It is a rebuttal. So we'll go into commercial agreement. Now, we've stated that in commercial agreements, there is a presumption that intention to enter legal relations is there, is present. But there are rebuttals. There are rebuttals. There are exceptions. Number one is when there is an assertion that their promise was a mere puff that should not even be taken seriously. So yes, in commercial agreement, we have the presumption of the presence of intention to enter legal relations. However, when there is this assertion that the promise was a mere puff, which ordinarily it cannot be taken seriously, then you cannot presume that there is intention for that person that made that promise to be legally bound. How do I mean? What do I mean? You know, we see some of these adverts. When we see Pepsi, will come and say, if you drink Pepsi, you will be a very good footballer. Now, to a reasonable man, to a reasonable bystander, because that is the test the court would still apply to this, the reasonable man test or the objective test. To a reasonable man, is it possible or is there any strand of possibility that if you take Pepsi, you would be a very good footballer? Now, there is none. Now, if you go and take Pepsi and you go and start playing ball and you don't play ball well, can you now sue Pepsi because they did not keep to their promise that if you take Pepsi? No, you cannot. Why? Because that promise that if you drink Pepsi, you play ball very well is a mere puff. And in mere puffs, you cannot say or you cannot presume that there is intention to enter legal relations in mere puffs. So if there is no strand of possibility, somebody have told you, for example, if you buy my course, you will be richer than Elon Musk in 1 week. That is exaggeration. When there is, that's a better word. When there is extreme exaggeration in your promise, that there is no, if there is no how a reasonable man will look at it and will think that this is possible. That is mere puff. When there is presence of mere puff, then you cannot presume that there is intention to enter legal relations. That is number one rebuttal. Another rebuttal is when it is expressly stated that the intention to enter legal relation is not there. What do I mean? There is a clause that says, see, anything we are doing in this contract, we do not have the intention to be legally bound. When it is there, it is expressed there, it is expressly stated in the contract, then you do not have the intention to enter legal relations. Why? Because you have excluded it from your contract expressly. That is why it is very important to have a lawyer go through some of your contracts, because some mischievous people that you are going into a contract with can slide it in there, and you do not want to involve a lawyer because you don't want to spend a lot of money. Now you go and enter into that contract when that other mischievous person has snuck in clause that excluded the intention to be legally bound, and you signed. Then the person has breached the contract and you want to bring the person to court, and the person presents or tenders the documents that you people used to enter into the contract. In your mind, you're happy because why is tendering the document that you use? Because of course there is a contract between us, and that is the evidence that there is a contract between us. Thank God, it's not even denying that there is a. You don't know that that evidence that he's bringing inside it is something that will make him win the case, because it is already there that we are not intending to be bound. And when he now brings it up in argument in court and they ask you, you signed now, you agreed, you will be confused because you signed, it is your signature. The effect of your signature is that you agree to the contract, you agree to the terms of the contract. So you will not see that it's not a problem. So that is why if you as a lawyer, you are expected to do your due diligence when your clients bring all these contractual agreements to you in order for you to review. Of course, when you have collected a lot of money, because if you don't collect a lot of money, those people will still go to court and spend that lot of money. But it's better to prevent than to cure. So that is it. So when it is expressly excluded, so you see this kind of clauses in lottery lottery contract when you want to go and play lottery. So in some of the agreements that you have to, in terms and conditions, you have to accept before you go into the whole playing of the lotto game, something. One of the clauses there is that they are not legally bound by anything, that you are only playing the game based on trust. Finish. Of course, most of you don't read terms and conditions. Just click accept. When something happens, you want to come to court, they will tell you you accepted our terms and conditions, and we said we are not legally bound, and you accepted. So we agreed. So you cannot bring us to court. Finish. So it's mostly in lottery games. So your exams might most probably come with a scenario of a lottery game and all that. So you have to read your scenario well in order to know if we are talking about excluding intention to enter legal relations. So another one we will be talking about is the intermediate situations, where it is not a commercial agreement, it is not a domestic and social engagement. But we have examples of when your friend has a car and you people usually go to work at the same area. You people are like four. You people agree. The five of you agree plus the owner of the car. That's five. Agree that the owner of the car will be taking you people to work because he also works at the same area. But you people will take turns in fueling his car. Maybe you can agree with your wife. Okay, this week I will be doing the school runs. Next week you do the school runs. School runs is going to get your children back from the school and all that. So these kinds of contracts are intermediate situations. Is there intention to enter legal relations? No, there is none. Yes, because there is a presumption that there is no intention to enter legal relations. After actually, the reason was explained that when, for example, you are trying to get money every day for fuel for the car and you share it in between four of you, that something might happen, some kind of event might take place, and one of them would not be able to perform his own part of the bargain due to some circumstances beyond his control. Now, what would then happen? Because this is a recurring situation, this is a recurring something. So your question might also come in form of you have a generator, people have connected their own rooms to their own lines, their lights to your generator with the agreement that they will be fueling the gen turn by turn. You just know that there is no intention to enter legal relations. So there's we've come to the end of elements of contract. Next time, okay, no, not really. Okay, we'll still look at capacity. Hi. Oh, I thought we have finished elements of contract. Okay, we'll still look at capacity. We're a little bit on capacity. Then we will enter terms of the contract, terms of your contract, terms of contract. Until we meet again. Bye bye.